Hello, everyone. Are the counsels for the appellant and the counsels for the respondent present?
Would it be possible if we could receive a minute or two so that the junior appellant could also join the meeting?
Sure.
Thank you very much.
I'm here. I'm junior counsel is also here for the appellants.
Hello, Your Excellencies. Hello, anyone hear me?
Yes.
Yes, we can.
Okay. Both the junior and senior counsel for the respondents are present. We are using the same device, so when I'm done,
Okay.
she will.
All right. Thank you.
Thank you. Okay, our names
So
are
now-
already on the chat.
Yeah. Yes. Thank you. All right. Now that the junior counsel for the appellant joined as well, we can start. We are also joined by Judge Rodrigo. So senior counsel for the appellant, you may proceed, please.
Thank you very much. Good afternoon, and may it please the court. We are presenting before you in this hearing of the Court of Appeal for the application submitted to the Digital Economy Court by Mr. Laith Payne. My name is Ms. Nabiha Khan, and I am the senior respondent on behalf of Mr. Laith Payne. I, along with my learned junior respondent, Mr. Momin Khan, will cover both the grounds, myself beginning with the first one. I'd like to begin with a summary of the facts of the case that are not in dispute. My client, Mr. Payne, is an avid user.
Your voice.
My client, Mr. Payne, is an avid user of the online cryptocurrency trading application Clevity. This application uses a currency called YAPL and algorithmic programming, allowing users to automatically make trades through programs of their creation. My client had one such program, Beta. This program allows the user to sell YAPL at a price based on the average price. However, if no other users are offering to sell YAPL, Beta automatically offers it for sale at an inflated price.
Counsel, I'm so sorry to interrupt you. Can you please state the allocated time for yourself and your co-counsel?
The allocated time for myself would be 10 minutes, and for my co-counsel would also be 10 minutes.
And for rebuttal?
For rebuttal, we'd like to reserve up to 5 minutes.
5 minutes each?
Yes.
Okay, noted. Thank you.
Thank you very much. Repeating my point, my client had one such program, Beta, and this program allows the user to sell YAPL at a price based on the average price. However, if no other users are offering to sell YAPL, Beta automatically offers it for sale at an inflated price. The defendant, Ms. Rani, also had one such program called Alpha, which is designed to buy YAPL at the best possible price available on the Clevity platform. On June 10, 2022, when both parties were sleeping, Clevity glitched and excluded all users below the cash margin of $200,000 instead of the usual $50,000. For 30 minutes, the only users on the platform were Ms. Rani and Mr. Payne, and therefore Alpha and Beta concluded a trade of 100 YAPLs, which I will be referring to as the disputed trade, at a price 250 times prevailing the market price. Clevity recorded the trade and debited $250,000 from Ms. Rani's account to Mr. Payne's. Ms. Rani issued proceedings in the DIFC Court's Digital Economy Court seeking a declaration for a unilateral mistake, and my client, Mr. Payne, issued an application challenging DIFC jurisdiction. It must be noted that the judge at the first instance dismissed both the claims on the grounds that firstly, DIFC courts have jurisdiction under Article 5A1 subsection B of the Bylaw number 12 of 2004. And secondly, that the court did not need to examine the state of mind of the programmer when designing the program. It was sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was that result of an error, citing Queen Private Limited versus B2C2 Limited in the Singaporean courts in the year 2020. The first ground of appeal is that the previous judge erred in law when stating that the DIFC court do have jurisdiction over the claim of Ms. Rasrani. To begin with, the rules of the DIFC Court's 58.76 states that a party who objects to the court's jurisdiction to decide a claim or counterclaim shall not be taken to have accepted the court's jurisdiction simply because they also defend the substance of the claim or counterclaim. This means that Mr. Payne was defending the fact that a mistake had not been made, so he did not accept the DIFC jurisdiction and should not be made to do so. Also, due to the fact that cryptocurrency is a relatively new topic in the field of law, the cases are quite limited. However, one of the major cases was the case of Alibaba Group Holdings Limited versus Alibaba Coin Foundation, case number 18CV2897. For the benefit of the court, may I reiterate the facts of the case?
Yes, please. Thank you.
Alibaba Group Holding Limited, which I will refer to as Alibaba, was a parent corporation for a multinational web services conglomerate, and they filed a suit against Alibaba Coin Foundation, which I will also refer to as ABBC Foundation, alleging that the defendants had been unlawfully using Alibaba's trademarked names and symbols to promote a cryptocurrency called Alibaba Coin. And in this case, the defendants were offering that allegedly stolen cryptocurrency for sale. This case showed that the defendant argued the court lacked personal jurisdiction over it because its ICO, or the initial coin offerings, did not occur in the US since the transaction consists of a ledger entries made in Minsk, Belarus, and following the observation of changes in blockchain data outside the United States. I would like to bring to the court's attention that because of the decentralized nature of cryptocurrency, it would be impossible to pin jurisdiction to one such location. Ledger entries, as previously stated, are recorded in multiple nodes worldwide, and therefore to settle on one jurisdiction simply due to the existence of a node in that location could cause several clashes of jurisdiction. It can be argued that if
Counsel, sorry if I interrupt you, but just to state the point clearly, we do agree with you that cryptocurrency touches many jurisdictions. But isn't it true that the DFC court jurisdiction will have at least concurrent jurisdiction in all those jurisdictions, and that the court in the CFI court had jurisdiction in this particular instance? Why will the fact that cryptocurrency touches other jurisdictions exclude the fact that the DFC court has jurisdiction on that particular matter?
I'm sorry, but won't the rebuttals happen after the respondent counsel have made their arguments?
For clarification, judges can ask questions during the submission. Rebuttals are for you to answer back or to argue back to the respondent's comments or arguments. But during the submissions, the judges are allowed to ask questions, just for clarification.
Thank you so much. I'm really sorry, but could you please repeat the last part of your question? I think my connection was getting weak.
Yes, thank you. So my question is the following. And I, as you're aware, there is no precedent in the DDC for this particular fact pattern, but there are many precedents regarding conflicts of jurisdiction between, for example, the Dubai courts and the DFC courts. And as you might be aware, under the judicial authority law, the DFC courts have jurisdiction on DFC establishments, and DFC govern contracts. And there have been in the history of this court cases where both courts, effectively concurrent system, the system of the Dubai courts and the system of the DFC court, claimed to have jurisdiction on one matter. And that's why the judicial tribunal was created, exactly to resolve this conflict of jurisdiction. But that said, until the judicial tribunal decides who has jurisdiction, in principle, the DFC court has jurisdiction. So I think the issue here is, rather than a positive proof that that crypto, as you said, touches many other jurisdictions, we're looking for a negative proof that the fact that the clarity that the servers were here is not sufficient to establish jurisdiction. So I think that's the issue in this case.
Thank you so much for your question. I'd like to begin by mentioning that when crypto transactions happen, the information of those crypto transactions can be stored in the distributed ledger, as how Clevity operates. However, that information of distributed ledgers, which are stored on nodes, do not have a specific allocation of which location that transaction would be recorded in. And also, just the mere storage of information of the transaction cannot be sufficient to determine that that specific area where the node exists would pinpoint the location of the jurisdiction of the transaction. For example, if two people conduct a trade in the Sultanate of Oman and Saudi Arabia, the transaction information could be stored in a node, for example, in Brazil. And it would be very unreasonable and in a conflict of law in many countries if the jurisdiction of Brazil applies to a transaction conducted in a completely different part of the globe. So my argument simply here is that just because a node exists in a region and in a location, it is not sufficient to pinpoint that that specific location can determine the jurisdiction because firstly, nodes are scattered all over the globe depending on what the platform is. And secondly, there is no confirmation and there is no way to completely 100% be sufficient with the answer that this transaction was recorded in this specific node, because that's the main point of when cryptocurrency was created, that it was decentralized. So no one specific law or jurisdiction of the world could completely govern it.
Thank you, Council.
Thank you so much. I will continue with my submission. With this, I would also like to cite the case of Gautama Shipping Limited versus Ghazi Shipping and Logistics and Geffen FZCO, case number 48, held in the DIFC Small Claims Tribunal in the year 2016. The facts of this case revolve around the claimants who alleged that the defendants failed to clear 16 of the 20 containers from the Jebel Ali port, that they were contracted to do so. This failure resulted in a significant detention and port storage fees being charged against the containers. On 11th April 2016, the claimant filed a claim in the DIFC Court's Small Claims Tribunal for reimbursement of the charges required to clear and return the remaining containers. The claimant claimed a total of $113,696.17 against the defendants, and both of the defendants responded to the claim by contesting the jurisdiction of the DIFC courts over the dispute. In this case, it is seen that as the parties were not DIFC entities and the agreements at issue were not performed or meant to be performed within the DIFC, there was no claim for jurisdiction. Therefore, the claimant's claim was dismissed as the DIFC courts lacked jurisdiction over the matter. Similarly, the blockchain node simply being in the DIFC area does not appoint it as a DIFC entity. If that were the case, then any node in any location worldwide would automatically become an entity of their surrounding area, rather than one single link in a larger network chain, that is cryptocurrency. This would in turn create many difficulties when interrupting the reach of a single node, as well as determining the area that a single node would represent would be tireless work. Moreover, according to Article 5A2 of the Judicial Authority Law, it is possible for the parties to agree in writing to the jurisdiction of the DIFC courts. However, the parties failed to do so. The appellants contested jurisdiction of the DIFC courts, and as such, this is considered a rejection to the opt-in of the DIFC court's jurisdiction. Therefore, as none of the relevant jurisdictional gateways of the judicial authority law apply to this case, it falls outside of the jurisdiction of the DIFC court, and the opt-in system of the DIFC cannot be applied as both parties have not agreed to do so. This is further reiterated by the case of Mindali versus Moot, case number 396 of the DIFC Small Claims Tribunal in the year 2020. Would Your Honor prefer a summary of the facts of the case mentioned?
No, thank you, counsel. You can proceed.
Thank you very much. In this case, it was held that the claim was dismissed due to lack of jurisdiction, as the DIFC courts can exercise its jurisdiction over a matter that is unrelated to the DIFC, where the parties have agreed in writing that any dispute arising between them would be referred to the DIFC courts for adjudication. In the present case, the matter must be deemed unrelated to the DIFC, as a single node cannot be enough to determine jurisdiction, and both the parties have not agreed in writing or in any such way to settle this matter in the DIFC. Further emphasizing the previous point on the decentralized nature of cryptocurrency, Torkin Main's article titled Blockchain Opportunities and Legal Considerations, published on 20th April 2022, states that theoretically, a given transaction could be governed by the applicable law in any jurisdiction where there is a node. Legal regimes across the world vary greatly, and it may be difficult and also, in some cases, impossible for a blockchain to comply with the applicable laws in every jurisdiction in which it has a node. Hence, this proves my point that jurisdiction cannot simply be pinned based solely on the location of one single node, as it would create several disagreements on node-related international legal matters. Thus, due to the aforementioned reasons, I urge the court to consider the lack of jurisdiction in this case and allow my client, Mr. Payne's appeal. Thank you.
Thank you, counsel. Junior counsel for the appellant, you may proceed.
Your
Good afternoon, and may.
Okay. Your Excellency, it is the rules of the competition clearly states that when the senior counsel for the appellant address the court, the next person to address the court is the senior respondent counsel.
Let me double check on that, because it's senior counsel for the appellant followed by the junior counsel for the appellant, and then upon completion of their submission, it would be the senior counsel for the respondent followed by the junior counsel for the respondent followed by the rebuttals.
Your Excellencies, I will urge you to double check again.
Okay, give us one minute. Thank you.
Thank you, Your Excellency. Your Excellency, can Your Excellency hear me?
Yes, we can hear you.
Okay, I am actually with the rules of the competition, particularly paragraph 2.1. There is a list of the orders which counsel shall be addressing the courts, and the first counsel there is senior counsel for the appellant, SA in brackets, and the second person that comes in line is the senior respondent counsel, SR.
What counsel for the appellant thinks about this? Do you agree with counsel for the respondent?
I would prefer making my submission immediately after my senior, because I feel like it would lead to a logical flow of argumentation.
I'm so sorry for the misunderstanding. Yes, the respondent is correct. We will proceed with the senior counsel for the respondent. Apologies for that. Thank you.
Thank you, Excellency. Okay. With utmost humility before this honorable court, entering appearance is Katie Philip, senior counsel for the respondent. Your Excellencies, before this court, there are two grounds of appeal, and myself, I shall be arguing the first ground, and my learned junior counsel shall be arguing the second ground. Prior to these proceedings, the respondent filed the respondent skeleton bundle, and it was filed and dated on the 4th day of November 2022. So the respondent shall be relying on all the averments, all the arguments, and as well all the prayers contained in the respondent bundle before this court. I now seek the leave of the court to go to the substance of the first ground of appeal. Your Excellency, I seek, with your kind permission, if I may proceed.
Yes, please proceed. Thank you.
Okay. In addressing this court on the first ground, I shall be using 25 minutes of the allocated time, while my learned junior counsel shall be utilizing 20 minutes of the allocated time. Ground one is to the effect that whether the trial court was not in error when it held that because Clevity operated a distributed ledger with a node located within the jurisdiction of the DIFC court have jurisdiction over the matter. It will be my contention before this court that the DIFC and the trial court was not in error. They were right to have exercised jurisdiction over this matter, and that the appeal before this court should be dismissed as lacking merit. In addressing the court on these points, I shall be premising my argument on two main standpoints. The first standpoint is that the node of the Clevity that is located within the DIFC court, within the DIFC jurisdiction, represents the entire platform of the Clevity. And the second standpoint of my argument will be that there is no exclusionary clause. There is no clause that the parties have agreed to opt out of the jurisdiction of the DIFC court. And as such, since the disputed trade was concluded wholly within the jurisdiction of the DIFC, relying on the authority of Lucin and Lloyd, the small claim tribunal case decided 2022, is to the effect that once there is no such agreement, ordinarily the DIFC courts will have jurisdiction by default. I shall now be moving to address this standpoint seriatim. On the first standpoint, which is that the node that was located within the jurisdiction of the DIFC represents the overall Clevity platform. The relevant law that regulates the jurisdiction of the DIFC court is Article 5A1B of the JAL. There are two criteria when, if satisfied, the DIFC court will have jurisdiction. The first criteria is that the said contract must arise as a result of commercial or contractual transaction. And the second is that the said transaction was concluded either wholly or partly within the jurisdiction of the DIFC. To understand the nature of the jurisdiction of the DIFC courts, the market analogy will go a long way in helping us to understand such. In a market analogy, different traders leave their different countries to come to the market and transact business. Any dispute arising from the transaction concluded within that market, it is the court within that market that will have jurisdiction to entertain such matters. Therefore, it is my contention that Clevity platform operates wholly within the jurisdiction of the DIFC courts. And the statement of fact clearly states that the Clevity platform operates a distributed ledger. For us to know whether Clevity is located wholly within the jurisdiction of the DIFC, it is pertinent for us to understand the nature of a distributed ledger. The nature of a distributed ledger is a form of computer network where it operates a decentralized network, where each node contains all the information within the platform. And each node can rightly be said to contain the entirety of the said platform. Because of the nature of the distributed ledger, there is no server, there is no controlling unit that controls other nodes. That is to say, other nodes contains all information that is contained within the server. And because Clevity operates a node that is located within the DIFC court, Clevity platform can rightly be said to operate wholly within the jurisdiction of the DIFC courts. And as such, giving the DIFC courts jurisdiction under the first criteria under Article 5A1B, that is, the contract is concluded wholly within the jurisdiction of the DIFC courts. Assuming but not considering that the said node located within the jurisdiction of the DIFC court is not the entirety of the Clevity network, it's just a branch of the Clevity network. The authority of Lucin and Nend decided in 2022, the small claim tribunal is of the view that where a multinational company has branches all over the world, and it has a branch located within the jurisdiction of the DIFC, and a contract was concluded within that branch that is located within the jurisdiction of the DIFC, and a dispute arose, it is the court of the DIFC that will have jurisdiction over such matters, because irrespective of the fact that the headquarters of the said company is not located within the jurisdiction of the DIFC. However, in this instant case, this is not even the case, because the Clarity network operates a distributed ledger, which means each node within the network can rightly be said to represent the entire platform. And because it has a node within the jurisdiction of the DIFC, the said Clarity platform can rightly be said to operate wholly within the jurisdiction of the DIFC. Moving on to the second standpoint of my argument, which is that there's no clause that exclude the jurisdiction of the DIFC that was agreed by the party that is prejudicial to the jurisdiction of the DIFC. And as such, ordinarily, the DIFC court should have jurisdiction by default. The elements of default jurisdiction of the DIFC court has rightly been stated in the case of Lucin and Noy.
So, sorry, counsel, apologies for interrupting. Before you move to the second argument, will you please state clearly your first submission that the DSC court has jurisdiction on what language the DSC authority law is based?
Okay, my first standpoint is to the effect that the Clarity platform has a node which is distributed ledger by nature, and as such, that said node can rightly be said to represent the entire Clarity platform.
Yes,
we
understand that. My point is, as you know, for the court to have mandatory jurisdiction, the dispute should fall within the threshold jurisdiction of the court, which is based on the DSC judicial authority law, right? So on what part of the judicial authority law are you relying on?
Okay, I am relying on Article 5A1B of the JAL to assert the fact that.
So are you saying that in this case we have a DFC establishment?
No, I am relying on the part of the law that clearly states that the DIFC court will have jurisdiction when the contract is concluded either wholly or partly within the jurisdiction of the DIFC courts.
Thank you, counsel.
Thank you, Excellency. Moving on to the second standpoint, which is that there is no clause that is prejudicial to the jurisdiction of the DIFC court. And as such, since the said disputed trade was concluded either wholly or partly within the jurisdiction of the DIFC court, ordinarily the DIFC court have jurisdiction by default. The element of jurisdiction by default has rightly been stated by the small claim tribunal in the case of Lucin and Land, where they listed two elements for the DIFC courts to have default jurisdiction. The first element is that the said contract giving rise to the action must have been concluded wholly or partly within the jurisdiction of the DIFC. And the second point is that the parties did not enter any agreement, a separate agreement that will give another court jurisdiction that is prejudicial to that of the DIFC courts. Looking at the fact of this case, both parties did not enter any agreement that is prejudicial to the jurisdiction of the DIFC court. There is no agreement as to that. And as such, since the contract was concluded wholly within the Clarity platform, which operates wholly within the jurisdiction of the DIFC courts, the DIFC courts in this instance have jurisdiction by default. And the trial court was actually very right. They were exercising their rightful jurisdiction by entertaining the said matter. And that the appeal before this court should be dismissed as lacking merit on these two standpoints of my argument. And with this, senior respondent counsel concludes this argument.
Thank you, counsel.
Okay, Your Excellency, if I may, I seek the kind permission of this court to make some comments on the senior respondent's argument, since I still have more time remaining within my time. Senior appellant counsel, rather, I wish to make some comments on her argument. I seek the kind permission of Your Excellency to continue.
If it's within your submission, you can make the argument.
Okay.
Within the time, thank you.
Yes, it is within my time. Thank you, Your Excellency. The senior appellant counsel made mention of the case of Alibaba as a case that should give this should be interpreted that the court of first instance should not have jurisdiction. However, for a case to have binding effect before this court, the judicial authority law, which regulates the jurisdiction of the DIFC courts, should be interpreted in that case, because it is the law that regulates the jurisdiction of the DIFC court. However, in that case, no mention was made to Article 5A1B of the JAF. Therefore, that case cannot be applicable because the subject matter and the ratio of that decision did not make reference to the law which regulates the jurisdiction of the DIFC court. On the second point she made, that the node located within the DIFC cannot rightly be concluded that it is the actual node that was used to conclude the transaction. Yes, it cannot be concluded that it is that node that was used to conclude the transaction. However, it can also not be assumed that it was not that node that was, it can as well be concluded that it is as well not reasonable to conclude that it is not that node that was used, in as much as we cannot conclude that it is that node that was used. However, it is only reasonable to assume that it is that node that was used, since it is that node that is located within the jurisdiction of the DIFC courts. It will not be reasonable if there is a node located within the jurisdiction of the DIFC and the said node that will be used to conclude the transaction will be a node in another jurisdiction. It will not be reasonable. It will only be reasonable for us to conclude that it is that same node that was used to conclude the transaction. So with this final response, I shall be rounding up my arguments and I shall be deferring proceedings to the next counsel.
Thank you, counsel. Junior counsel for the appellant, once you're ready, please proceed.
I'm ready.
I'm sorry to interrupt, but when can the senior appellant argue for rebuttal?
So once the junior counsels for the appellant and respondent complete their submissions, we will proceed to rebuttal.
Thank you so much for your clarification.
Thank you, counsel.
Your Honor, I would like to request that if it is possible, that I may be afforded 5 more minutes of the time, because I didn't discuss with my senior how the allocation of time was going to be in this case, and I feel like I might go over the 10 minutes unless I speed through my case.
Yes, of course, that's fine. So would you like 15 minutes for the submission instead of 10 and 5 minutes for rebuttal? Yes? Okay.
Yeah.
Please proceed.
Okay.
Thank you.
Good afternoon, and may it please the court. As introduced by my learned senior, Ms. Nabiha Khan, my name is Mr. Momin Khan, junior counsel for the appellant, Mr. Leith Payne. As stated by my learned senior, I will be addressing the second ground of appeal. For the benefit of the court, I shall reiterate the ground of appeal and relevant facts that I will be contending with. Firstly, my client's argument. Mr. Payne argued that there could not be a relevant mistake within Article 37 of the DIFC contract law. Mr. Payne said that even if Ms. Rani had made a mistake when he programmed Beta, he did not make the same mistake as Ms. Rani or cause her mistake, and he did not know and could not have known about Ms. Rani's mistake, and so there could be no grounds to avoid the disputed trade. Secondly, the court's assessment was that it did not need to examine the state of mind of the programmer when designing the program. It was held that in the court of first instance, that it was sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. In reaching this conclusion, they cited Lord Mans from the case of Coin Private Limited and B2C2 Limited, reported in the 2020 Singapore International Court of Appeal on page number 2. Your Honor, with these facts laid out, I will now begin with my submission that the judge in the court of first instance erred in his application of law regarding Article 37, Section 1, subsection A. Firstly, I would like to discuss the case of Coin Private Limited and B2C2 Limited reported in the 2020 Singapore International Court of Appeal on page number 2 in 2 parts. The first being the arguments put forth by it as the facts of it may be beneficial to our current situation. And secondly, Lord Mans's judgment as applied by the court of first instance. The facts of the case are quite similar, so I shall reiterate them for the benefit of the court. May I proceed?
Please go ahead.
Coin Private Limited was a trading platform on which an error had occurred. This resulted in the algorithms of the parties involved, namely B2C2 Limited and others, concluding trades at a highly inflated price. The trading platform had reversed the trades after taking note of them and realizing they were caused by an error on their platform. B2C2 Limited brought a claim against them to recover the riches they gained from the error on the grounds of breach of contract or breach of trust. Breach of trust is not relevant to my submission, so will not be discussed, but the judge did rule in their favor. Coin filed an appeal, but their appeal was dismissed, leading to this case before the Singaporean Court of Appeal. The majority in this case ruled that when deterministic algorithms were doing the trading in respect of their programmers, the state of mind of the programmer must be analyzed from the creation of the algorithm until the conclusion of the contract in question. Mr. Payne's state of mind when designing beta could be subject to much speculation. However, it must be noted that when the programmers of B2C2 had designed their algorithm, they did not design it to benefit from volatile market conditions. The parameter to conclude a trade at an inflated price was to ensure that the algorithm did not break and stop working in extreme market conditions, which, as we know, are quite common in the world of cryptocurrency. It can be argued that this was Mr. Payne's intention as well, as he could not have realistically predicted an instability in the market that would have resulted in his benefit. If Mr. Payne did not become aware of this possibility at any time prior to the conclusion of the contract, there is nothing that can be said regarding his knowledge of the mistake according to this case. This conclusion means that Mr. Payne did not make the same mistake as Ms. Rani, as he was just trying to ensure the continuing functioning of his algorithm. And he could not have caused her mistake or known of the mistake, as the trade was concluded by deterministic algorithms in the complete absence of human input at the time of the formation of the contract. I would like to elaborate further on this point in my second submission regarding Coin. For my second submission regarding this case, I would like to bring to the court's attention that Lord Mance was providing a dissenting judgment, and his approach was criticized by the majority for a number of reasons. Firstly, Lord Mance's approach was scrutinized as being wholly artificial because it attempted to claim that the trade was concluded in a hypothetical on-the-floor meeting and not through pre-programmed algorithms, and that the final contract was entered into on terms that were not within the program parameters of the parties' algorithms. The majority in the Court of Appeal in this case argued that the parties had chosen to do their trading through algorithms, and it follows that any trades concluded by said algorithms would not be mistaken trades so long as they were concluded within the parameters set by the programmers. As I've already established, Mr. Payne did not know of or cause Ms. Rani's mistake in this case. The disputed trade was concluded by her algorithm within its preset parameters, and Mr. Payne's algorithm only sought to retain continuous function with its deep price parameter. It follows that the approach adopted by the majority should be considered more apt in this case. It is also important to note that the Singaporean court was applying the equitable doctrine of mistake at equity. No such approach exists in the English courts or the DIFC courts, and this statement can be supported by paragraph 90 of the Coin case found on page 238 to 239 of the appellant court bundle. For my second submission, I would like to bring to the court's attention the case of Smith and Hughes, reported in volume 6 of the 1871 Queen's Bench Law Reports on page number 597. This case has provided a long-standing authority for the doctrine of unilateral mistake at common law and serves as a much stronger basis than the doctrine of unilateral mistake at equity. In this case, the defendant mistakenly assumed he was buying old oats from the claimant and refused the contract once he had realized the contract was for new oats. The plaintiff sued the defendant and racehorse trainer for a breach of contract for the sale of oats. It was held that the unilateral mistake may only apply to the terms of a contract, and one party holding a mistaken belief is not enough to void a contract. Your Honor, as I have previously established, Mr. Payne did not make a mistake as to any terms of the contract, and he did not cause Ms. Rani to hold the mistaken belief that he intended to take advantage of. Ms. Rani held the mistaken belief that her algorithm would not lend itself to concluding a trade that would not be beneficial to her, and had taken no countermeasures to prevent such a situation. Mr. Payne, on the other hand, was aware of the fluctuations that occur every so often in the market, and had taken preventative measures only to ensure his algorithm would remain online and functional. There was no mistake here as to a fundamental term of a contract, only the mistaken belief of one party that there would never be an unfavorable market condition. It is my contention that under the doctrine of unilateral mistake recognized by the English courts, Mr. Payne should not be penalized for Ms. Rani's unpreparedness under the circumstances of this case. Through my previous two submissions, I have established that the mistake is no fault of Mr. Payne's. However, I would like to submit now that it is in fact Ms. Rani who is entirely at fault for this situation under DIFC contract law. I would like to bring to the court's attention the case of the Crown on the application of Software Solutions Partners Limited and Her Majesty's Commission for Customs and Excise reported in the 2007 England and Wales High Court on page 971. In this case, the claimants, Software Solutions Partners Limited, were providers of a program that allowed insurance brokers to expeditiously prepare insurance contracts with insurers. The program worked by accepting the input of parameters by the insurer and outputting a contract that fell within those pre-programmed parameters. It was held that even in the event of a system error, the insurers would still be legally bound by the contract within limits, even if they were temporarily unaware of the resultant contract terms. This software is analogized with parking meters in Thornton and Shoe Lane Parking Limited, reported in Volume 2 of the 1971 Queen's Bench on page 163. The analogy I'm referring to can be found in paragraph 66 of the Software Solutions Limited case judgment on page 128 of the appellant's court bundle. In that paragraph, the court accepted that such a software is similar to the parking meter in that case, as Lord Denning had so aptly put it. The customer pays his money and gets a ticket. It can be translated into offer and acceptance in this way. The offer is made when the proprietor of the machine holds it out as being ready to receive the money. The acceptance takes place when the customer puts his money into the slot. These situations are very similar. These situations are relevant to my client's appeal as the method of transactions are very similar. Mr. Payne had programmed these algorithms to sell Yapple at the best available market price, and in the event of there being no best available market price, at a highly inflated price to ensure it remains operational. Mr. Rani's algorithm bought Yapple at the best available price, and consequently, in this case, at the highly inflated price. Ms. Rani's algorithm works similarly to the way an insurer would put parameters into a program and be bound by the contract that was formed thereafter in Software Solutions Limited. She provided an input and she received an output. Even in the event of an error by her algorithm, she should be bound by the result as the insurers were in Software Solutions Limited. The end result still fell within the program parameters of her algorithm, so it cannot be said that this was a consequence that was entirely unforeseeable. Her input of parameters should indicate full acceptance of the offer as they were in the ambit of her programming, similar to the case of Software Solutions Limited and the case of Thornton and Shoe Lane Parking. Bearing these facts in mind, I would like to make 2 points for my final submission, one statistical and one legal. Firstly, the manager and writer of the Quantified Strategies website, Odman Growit, penned an article titled, "What Percentage of Trading is Algorithmic? Algo Trading Market Statistics, Growth, Trends, and Forecasts." In this article, he mentions that a study concluded in 2019 found that 92% of Forex market trading was done by algorithms and not humans. And according to Select USA, a federally backed United States summit held by the US Department of Commerce's International Trade Administration, it was found that around 60 to 75% of all US equity trading was carried out by algorithms. It is evident from these statistics that algorithmic trading is no recent phenomenon that took the world by storm. It is a well-established and practiced method of trading globally. With that said, I would like to establish the second part of my final submission by redirecting the court to DIFC Contract Law, Article 37, Section 2, Subsection B. The provision states that a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of the mistake was assumed, or, having regard to the circumstances, should be borne by the mistaken party. Your Honor, I contend that with these statistics in mind, Ms. Rani should not be allowed to avoid the contract with Mr. Payne, as the risk should have objectively been in her reasonable contemplation, and as such is a risk that should be borne by her, the mistaken party. This concludes my submissions for the second round of appeal on behalf of Mr. Leith Payne. Your Honor, on these facts, I request that the decision of the court of first instance be overruled and the appeal be allowed. Thank you.
Thank you, counsel. Junior counsel for the respondent. You may proceed once ready.
Good morning, Your Excellency. Am I audible?
Yes.
All right, Your Excellency. I will be canvassing my argument on ground 2 of the statement of fact. Your Excellency, I would like to read the issue. Ground 2 states that the first instance court, in concluding that for the purpose of a claim to avoid a disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi showed that a reasonable trader with knowledge of the circumstances surrounding a transaction would have concluded that the disputed trade was the result of an error. Your Excellency, counsel is submitting that the trial court did not err in holding that the transaction was void. And this submission is not based on thin air, Your Excellency. It is based on statutory authorities and judicial authorities. Your Excellency, counsel will rely on Article 37 sub 1A of the contract law, Article 3.5 of the Unit Principles, and the case of Hastings and Hazel provided in the footnote 12 of the respondent's bundle. Your Excellency, on Article 37 sub 1A, the import of that provision is that where a party, a reasonable person in the shoes of the party, sees that if knowledge of the true situation of things was known, he would not have continued with the transaction. And if the other person was knowledgeable as to the mistake, if he caused the mistake, or he ought to have known that such a mistake was in existence. Your Excellency, counsel is asserting that all the elements provided in the contract law are applicable in this particular case. Counsel would like to bring the knowledge of the court to paragraph 4 to 6 of the Moot Fact. Your Excellency, in paragraph 4 of the Moot Fact, it can be seen that Ms. Razi programmed Alpha to purchase Yapo at the best price available. Your Excellency, Counsel's emphasis is on the best price available. Then from paragraph 5 of the case fact, it can also be seen that due to the upgrade on the Clarity platform, there was a fundamental malfunctioning of the Clarity platform. This caused the platform to exclude persons who were legitimately entitled to partake in transactions on the platform, leaving just 2 persons, which are the parties to this dispute. Your Excellency, due to the error, the high price program, the high price factor in the appellant's algorithm was kickstarted, which led to the sale of Yapo at a whooping 250 times over the actual market price. Your Excellency, I would like the court to understand the fact that the algorithm of the respondent made a mistake owing to the fact that that was not the best available price at the time. Actually, it was the only available price and there was no other seller on the platform at the time. The instruction or the programming of the respondent's algorithm was to purchase at the best price. Best, Your Excellency, is a superlative form of good. It comes in context of comparisons, good, better, best. But in this particular case, there was no other seller from which the algorithm could compare. The algorithm erroneously went ahead to purchase the only available, he went ahead to purchase from the only available seller, not the best price. Going further, Your Excellency, the appellant's algorithm was programmed to sell at a highly inflated price when there are no other users to sell their point. This is from paragraph 4 of the statement of facts. But Your Excellency, due to the error, as I earlier stated, all other legitimate persons who were entitled to transact at this time were excluded. It wasn't a case of no offer. There was only one offer because of the fundamental malfunctioning. The algorithm kickstarted the high price inflation rate just because of the error that was on the platform and not because other persons refused to sell. Both algorithms were mistaken as to the true position of things at the time this disputed trade occurred. Your Excellency, a pertinent question I would like the court to take note of is, would any reasonable man, knowing that a fundamental malfunctioning had occurred on the system, a malfunction that excluded persons who were legitimately entitled to transact, persons who had up to $50,000 as had been agreed by the contract rules, but the platform allowed only persons having $200,000. Your Excellency, when one goes to the market, one has the opportunity to survey from a host of sellers to see which of them would fit one's budget. But in this case, it was only one person. In fact, Your Excellency, rather, I can say that it was not really a choice. There was no market here. He was forced to buy, thinking that that was the best price, whereas it was the only available price. It is visible to the blind and audible to the deaf that no reasonable man would purchase at about 250 times above the actual market price. Your Excellency, if it was 1, 2, 3, 10, 50, then perhaps we could discuss about that. But it was a whooping 250 times over the actual market price. Your Excellency, Counsel implores the court to consider the mandate of the DIFC court. It is to ensure that it is to promote digital financial transactions. But Your Excellency, if this erroneous transaction is upheld by the court, it would dissuade a lot of persons from participating in cryptocurrency transactions on cryptocurrency platforms, because this sort of error could occur. And it means persons would have to cope with the detrimental effects and the huge damages that could occur. It's in the interest of justice, in the interest of the respondents, in the interest of technological advancement, that this particular erroneous transaction be voided. And as I said earlier, Your Excellency, this is not based on thin air. This fulfills the conditions stated in Article 37, Sub 1A of the contract law and reiterated in Article 3.5 of the Unit Right Principles. no reasonable man would have continued with the transaction, knowing that these errors were existent at the time. Also, both parties were mistaken as to the actual truth of actual position of things. Your Excellency, counsel submits that the trial court did not err in its position that the contract should be voided. And counsel praised this court in the interest of justice, in the interest of technological advancement, in the interest of promoting the mandate of the DIFC court, that this particular transaction be voided and the appeal should be dismissed. If the court has no further use of counsel, counsel would like to defer proceedings. Your Excellency.
Please go ahead.
Counsel prays that this court should dismiss this case and hold in favor of the respondent. Your Excellency, counsel has concluded with her argument.
Yes, submission complete, counsel?
Yes, Your Excellency.
Thank you.
Thank you very much, Your Excellency.
We will now proceed with the rebuttals. Senior counsel for the appellant, you may proceed once ready.
Thank you so much. Your Honor, I would like to submit 3 arguments for my rebuttal. The first, Article 5A1B of the Judicial Authority Law mentions that civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalized, or performed within the DIFC. The senior respondent argued that the transaction was wholly concluded in the DIFC, which is incorrect, because even if Ms. Rani utilized the opt-in jurisdiction of the DIFC, my client, Mr. Payne, resides in the Sultanate of Oman, making it impossible to allocate Article 5A1B of the Judicial Authority Law. Consequently, this closes the broadest gateway of the application of DIFC jurisdiction. Second, I would like to once again mention that it cannot be argued that Clevity's node present in the DIFC makes Clevity a DIFC establishment. Even if it is looked by an alternative approach, the cryptocurrency YAPL is not issued by any monetary authority and therefore cannot be entitled to any legal claims, once again supporting the argument that Clevity or the YAPL transaction is not related to DIFC activities. And my last submission is that, based on the numerous authorities cited in my speech, I would like to emphasize on the fact that the mere presence of a singular node in the DIFC does not and cannot appoint DIFC's jurisdiction over the disputed trade. On the contrary, I failed to find substantial authorities in my learned respondent's speech supporting that DIFC jurisdiction applies. For a court to decide a case, it requires legal authorities rather than analogies and hypotheticals. And therefore, I'd conclude my rebuttal. Thank you very much.
Thank you, counsel. Junior counsel for the appellant, please proceed with your rebuttal.
Thank you. Firstly, I would like to ask the court, is it permissible for me to clarify something with the opposing counsel?
You can mention it in your rebuttal, but she cannot, the opposing counsel cannot answer you back.
Okay.
You want to
I would
ask
like to reiterate.
Mm-hmm.
I can reiterate my learned senior's point that I failed to find any substantial authorities mentioned by my learned opposition counsel, and I believe that the arguments made were purely hypothetical or conceptual, and no actual case law was cited, but I might have been mishearing. So I would just request clarification from the opposing counsel on that matter. And secondly, while my argument went through the different motions of why Mr. Payne is not, why Mr. Payne should be able to keep the contract, and then establishing why it's Ms. Rani's fault, I did not see any application on the opposing counsel's behalf regarding DIFC contract law. That's all that I have.
Thank you, counsel. Judge Rodrigo, the submissions have now been complete. So if you have any comments for the councils.
Yes, thank you. So I would say in general, well done everyone regarding the materials. You clearly done your job. You know the facts, you know the case, and you thought carefully about your submissions. I have some remarks in general, but that you know that hopefully will be useful in your professional career as advocates. Okay, so going in order to Nabita, always be prepared for questions. There will always be, so questions are not only coming from the other side, they come from the court, they come from the arbitral tribunal, if you ever do arbitration. So the purpose of advocacy is not really for advocates to do a monologue and for everybody just to listen and silently. The court litigation and arbitration are a dialogue between the court, between the decision makers, and counsel. So don't always plan your speech so that nobody will interrupt you, because you will be interrupted. But anyway, you responded well to the question, so eventually you respond to the question, but be ready for that. Then I have to Momin. Well, regarding this last rebuttal, in general, I think you're aware of this, but be mindful that again, you speak with the court, and you speak with the arbitral tribunal if you're in arbitration. You never this dialogue that I mentioned is between the court and counsel. It's never between counsels among themselves. So if you have comments or questions for the other side, or you want to remark what you think was not done properly by the other side, is for you to tell this to the court. The court then will make its conclusions. And then going to the other team. So first of all, would you mind spelling your names? And that's a general, again, remark. So this is a digital economy, Moot. We live in a digital age. So as much as it's nice to do things in person, these things take place on Zoom. So for the team, the University of Benin, I will say it would be helpful if you could spell your name in your account, because it's not always easy to hear the spelling of your name, and it's for you as advocate. In the future, you want your name understood clearly. So that's my advice for the next Moot. Put your name in your in your Zoom account. Could you please spell your names?
Your Excellency.
Yes.
My name is Katie Philip, and
Kitty Philip. Okay.
I will still spell my name, but however, we've dropped our name on the chat box before during the proceedings. But I'll still spell my name, Katie Philip. Philip is spelled as PHILIP.
Okay, and your colleague?
Your Excellency, my name is P. Usiosefe. I'll spell Usiosefe, USIOSEFE, with the initials P. I am the junior correspondent counsel.
Thank you. I'm sorry, somehow I didn't receive your chat message. You probably sent it before we were transferring to the room. But as you see, that's my advice in general. You want your name to get around, people to know who you are in general for your career as advocate. So be always mindful of that.
Yes, sir. Thank you very much.
And general maybe comment would be, again, stick, especially as you know here, the jurisdiction was the very tricky part. Be mindful that jurisdiction is differently from contract law or tort law, where sometimes the court has some authority and might create new case law when it comes to jurisdiction, is really within, you know, the corners of the statute. So always spell clearly for the court to what statute are you referring for, what aspect of the statute are you referring for? Because you remember I asked this question because it was not immediately clear what section of Article 5 you were referring to. So start always from the statute. That's all for me. Thank you.
Thank you, Judge. Thank you all so much and well
Thank
done.
you, Excellency.
Thank you.